Good afternoon, everybody. This is Roy Breitenbach, and this is the next webinar in our nursing home series. And the topic for today is your facility ADA accessible? We're going to be talking about the Americans with Disabilities Act and various issues regarding the ADA. What we'll specifically discuss is, first of all, talk about the obligations under Title III of the Americans with Disabilities Act, and as well as some state and local laws. I'll then talk about specifically a topic that's always on everybody's mind, which is the obligation to provide sign language interpreting services to residents who are deaf. We'll then talk about service and emotional support animals, the issue of physical accessibility, website accessibility, another very hot topic, and the Department of Justice's newest issue, which is the question of opioid use disorder. I'm going to go probably about 45 minutes today, depending upon how in depth we get into some of the topics. But if you have any questions, you can enter it into your field anonymously, and we'll try to answer them at the end. So let's now go to the heart of the order. Well, all of these issues, the entire issue of disability access really starts with the Americans with Disabilities Act, which was passed by Congress and signed by President George H.W. Bush in 1990. It was the first statute that prohibited discrimination against people who are disabled, and what's relevant for nursing homes in the area of providing accommodations to residents is Title II and Title III of the Act. Title III governs public accommodations. It sets forth the obligations by which public accommodations must avoid incidents of disability discrimination. And public accommodations under the statute includes any business that offers its services to the public. So nursing homes, nursing facilities, whether they be for-profit or not-for-profit, are governed by Title III of the Americans with Disabilities Act and have to follow the requirements of the Americans with Disabilities Act. Now, if you're a governmental entity, so if you're a municipal or a state facility, you're governed by a different title. That's Title II, which prohibits disability discrimination by governmental entities. For our purposes today, they're functionally the same. There are some slight differences, and as we go along in this webinar, we'll talk about those differences. Now, the ADA is not the only statute that governs disability discrimination. There was a federal statute before the Americans with Disabilities Act, which still applies in many circumstances, and that's the Federal Rehabilitation Act. The Federal Rehabilitation Act prohibits disability discrimination by entities that are receiving federal funds. And since most nursing facilities, by definition, receive Medicare or Medicaid reimbursement, they are governed and they are subject to the requirements of the Rehabilitation Act. Most of the substantive parts of the Rehabilitation Act track the Americans with Disabilities Act. The one major difference, which we'll talk about later, is that under the Rehabilitation Act, in certain circumstances, a person who is disabled can obtain money damages for disability discrimination. The Title III of the Americans with Disabilities Act does not allow or call for damages. Now, in addition to these federal statutes, there are also local and state laws, right? The New York State has a human rights law, which also prohibits disability discrimination, and it's interpreted in much the same way as the Americans with Disabilities Act. New York City has its own human rights law. It's known as the New York City Human Rights Law, and that's interpreted in much the same way as the Americans with Disabilities Act, but based upon some statements made by the New York City Council in the last decade, it appears that a court should construe the New York City human rights law much broader than the ADA. So things which may not violate the ADA may violate the New York City human rights law. So for facilities located in New York City, you're subject to a much broader statute. And then both New Jersey and Connecticut have their own local laws which prohibit disability discrimination for nursing facilities. And in Connecticut, it's the Connecticut Human Rights and Opportunities Act. And in New Jersey, it's the New Jersey Law Against Discrimination. There's also a provision of the Affordable Care Act, or as it's known colloquially, Obamacare, and that's Section 1557, which also requires covered entities such as healthcare providers, nursing facilities, to afford certain reasonable accommodations to persons who are disabled. And while the law on Section 1557 is still developing, it appears that it would track pretty much the same requirements as the Americans with Disabilities Act. And finally, there's the Fair Housing Act, because nursing facilities do provide housing to residents on a less than short-term basis. Nursing facilities are subject to provisions of the Fair Housing Act, which itself also prohibits discrimination in housing accommodations with regard to persons who are disabled. So we'll talk a little bit about the Fair Housing Act as well. So that's kind of the field of what we're going to be talking about. Let's now go focusing on Title III of the Americans with Disabilities Act and really what obligations it sets up for persons who are disabled. So broadly, Title III of the Americans with Disabilities Act prohibits discrimination against persons with disabilities. And there's a definition to who is disabled. And you're disabled under the Americans with Disabilities Act if you suffer from a condition that impairs one of the major bodily functions. So, for example, deafness, blindness, problems ambulating, diabetes, high blood pressure, all of those things can be considered disabilities under the Americans with Disabilities Act. It's a pretty broad category. And if you take a look at the New York State Human Rights Law and the New York City Human Rights Law, the definition of disabilities under those statutes are even broader. So a lot of conditions constitute disabilities. Usually, unless they're very short-term problems that don't really have an significant impact, it will be considered a disability. So Title III says public accommodations, which would include nursing facilities, can't discriminate against persons with disabilities. However, Title III just doesn't say that. Just doesn't prevent you from discriminating. It also puts affirmative obligations on public accommodations, including nursing facilities. It says, not only can you not discriminate by, not admitting persons with disabilities, treating them differently, you have to undertake an affirmative action. And those affirmative action is called a reasonable accommodation. You have an obligation to eliminate barriers that prevent persons with disabilities from fully enjoying the facility services. So, for example, the services that your facility provides is skilled nursing services in most cases to help people with certain conditions. So under the Americans with Disabilities Act, you have an obligation to ensure that your residents who have disabilities have barriers eliminated that would prevent them from enjoying their services, right? So you have to make reasonable accommodations to remove those barriers. So, for example, if a person is in your facility because they've had a stroke and they need help with physical therapy, occupational therapy, and other therapies in order to go back to their lives, and they also happen to be deaf, you as a facility have an obligation to provide them with reasonable accommodations so that they can overcome the barrier of deafness that prevents them from fully enjoying your rehabilitation services. That's one example. And so it's this affirmative obligation that makes the ADA and the relevant state and local laws different than all other discrimination laws. It's not just prohibiting you from doing something, you have to take an affirmative step. You have to make reasonable accommodations to remove disability barriers. Okay? And if you don't make those reasonable accommodations, then your failure to do so constitutes an incident of disability discrimination under the Americans with Disabilities Act. All right? So let's talk about what some of these types of reasonable accommodations could be, right? Well, there's basically three main types. The first one would be making required changes to policies or procedures. Second one is to provide auxiliary aids and services. And the third one is removal of architectural barriers. Okay? So required changes to policies or procedures, right? You may have to make a change to a policy or procedure because it serves as a barrier to a person due to their disability. Classic example, if you have a resident, a potential resident who comes to your facility, okay, and you have a policy when they come to your facility that all potential residents have to fill out a particular application form themselves, right? When the person is blind, their blindness is a barrier due to disability that prevents them from complying with your policy of personally filling out a form. So you have to change that policy. You have to make a reasonable accommodation to change that policy in order to remove the barrier of blindness that's preventing them from receiving your services. That's an example of required changes to policies or procedures. Another good example of a required change to policy or procedure is in the area of service animals. You may have a policy in your facility that prevents animals from going into certain parts of your facility. That's a facility-wide policy, okay? But a person who uses a service animal, and we'll talk about this in depth later, because of their disability, a reasonable accommodation that you and the facility will likely have to make is to waive that policy prohibiting animal access so as to enable a person who relies upon a service animal due to their disability to access your facility. That's another example of a change to a policy or procedure. In addition to making required changes to policies or procedures, in certain circumstances, facilities also have to provide auxiliary aids and services to enable their residents who have disabilities to fully enjoy their services. Prime example of this is the provision of sign language interpreting services, right? That sign language interpreting services is an auxiliary aid and service. So a person who is deaf who comes to your facility, and one of the services you offer as a skilled nursing facility is to provide them education, let's say, about their condition and to do a rehabilitation assessment, for example. Well, they can't fully participate in the rehabilitation assessment because they're deaf and they can't communicate with the therapist who's doing the assessment. So you may have to provide the auxiliary aid and service of a sign language interpreter to remove that barrier caused by their disability, which prevents them from successfully completing the rehabilitation assessment. And then the third type of reasonable accommodation is the removal of architectural barriers. If a person has a mobility disability and they can't access a portion of your premises or a service because of their mobility disability, the facility may have to remove a barrier, a physical barrier, in order to enable them to access the facility. So those are the three types of reasonable accommodations. Now, before we go on to the next subject, it's important to emphasize that the statute requires reasonable accommodations, not all accommodations. The accommodations have to be reasonable, and reasonableness is determined on an incident-by-incident basis. If the accommodation is going to impose an undue burden on the facility in terms of cost, or in terms of effort and time, there may be certain circumstances where you do not have to provide the accommodation. If the accommodation that's requested would fundamentally alter the nature of the goods and services provided, then you may not have to provide it. Or if the accommodation itself would cause a direct threat to health or safety, you may not have to provide it. Classic example of the third, direct threat to health or safety. You, in a nursing facility, may have locked doors because you're concerned about residents who may be wanting to elope from a particular floor or unit. If you accept a patient who has, in addition to whatever rehabilitation issues, has an anxiety disorder that causes them to irrationally decompensate when they're on a locked floor or in a locked unit, the very fact that they're locked in causes undue anxiety. That resident asks you for an accommodation by unlocking the unit so that they don't feel anxious. You as a facility may not be able, you can most likely say we cannot do that because that would pose a direct threat to health and safety for other residents. That's an example, okay? So remember, it's reasonable accommodations. So let's talk specifically regarding the provision of auxiliary aids and services and sign language interpreting services, which I think is probably where this will come the most in talking about in your facility. So in order to provide equal access, as we said, a public accommodation must provide auxiliary aids and services, particularly for people who are deaf or hard of hearing. The concept is a person who is deaf has to be provided the same access in terms of communication about their medical condition, treatment, and prognosis as would a hearing person with the same condition. So you have to make sure when there's substantial information that you need to communicate to a resident who is deaf, that person has to be able to receive that information, notwithstanding the fact that they are deaf. And if you have to provide an interpreter for them to do it, then that's what you have to do. You have to provide them with an auxiliary aid or service to enable them to reach the same result, get the same information. But what's important to note, and this is particularly important for nursing facilities, this is not a 24-hour-a-day, 7-day-a-week obligation, okay? Particularly in a nursing facility context. You do not have to always have a sign language interpreter on call. You can identify when there are significant interactions in which it's particularly important for the resident to receive information and provide sign language interpreting services for those interactions. For example, every day when the aide comes into the room to address the patient in the morning, that's a routine type of visit in which not a lot of significant information is communicated between the aide and the resident, and there may not necessarily need, in most cases, to be an interpreter present for that. But when the resident is undergoing their initial rehabilitation evaluation and they're being interviewed by the therapist to come up with a rehabilitation plan, well, an interpreter may be almost certainly required for that type of interaction. Same thing, if there are bi-weekly plan of care meetings with social work and other members of the staff of the facility, you may have to have provided interpreter for that, because that's significant interaction. Okay? Auxiliary aids and services don't just include qualified interpreters, they also can include note takers and written materials. In certain circumstances, you may be required or able to provide written materials to satisfy your obligation. The type of auxiliary aid or service depends upon what's needed in a specific situation. It also depends on the person who is deaf or hard of hearing. And that's an important point, because not all persons who are deaf communicate in American Sign Language or even know American Sign Language. If somebody, for example, was deaf later in life, they may never have had the opportunity to learn American Sign Language, and providing that person with a sign language interpreter would functionally be meaningless, because they wouldn't be able to communicate through an American Sign Language interpreter. So in that case, you would have to provide another auxiliary aid or service to help that patient, and that could potentially be such things as written notes, lip reading, or something else, right? Also, there are certain circumstances in which a person who is deaf understands sign language, but doesn't necessarily use American Sign Language. There are other types of sign language, such as British Sign Language, French Sign Language, Russian Sign Language, or kind of other forms of ASL that are kind of very informal, where a formally trained interpreter using American Sign Language may not be able to communicate with a particular deaf person. Your obligation is to provide a qualified interpreter, and therefore each situation is unique, okay? Let's talk a little bit about qualified interpreters. The definition in the Americans with Disabilities Act, and this definition will kind of follow through to the other statutes, is that the interpreter must be able to interpret effectively, accurately, and impartially, both receptively and expressively, so both talking and listening, using any necessary specialized vocabulary, right? So that's an individual inquiry on a patient-by-patient basis, whether a particular person, given the resident's requirements, is a qualified interpreter. An individual does not have to be formally certified by any organization in order to meet the qualified standard, as long as they're able to interpret effectively, accurately, and impartially. And family members are almost always not considered to be appropriate interpreters because of their emotional or personal involvement, and because it's difficult to maintain confidentiality. Our recommendation is almost never to use family members as interpreters. Only use them as a last resort in an emergency situation. Okay? Key interaction when effective communication is needed. For example, discussing the patient's medical condition, symptoms, and history. So an initial rehabilitation evaluation, such as we talked about before. Reviewing, explaining, or obtaining informed consent, healthcare proxies, things like that. Explaining medications being prescribed. The new medication is being prescribed to the patient, and the patient needs to know when to take the medication, what the potential side effects are. That's an example of a time when effective communication is needed, and you may have to provide an interpreter. Explaining aftercare or discharge instructions, and dealing with complex discharge planning, billing, and insurance issues. All issues in which you may have to provide an interpreter because effective communication has to occur. Your obligation to provide an interpreter is not limited to providing a live in-person interpreter. There is also video remote interpreting services, which are Skype-like services, in which the interpreter is at a remote location, and through a video and audio link through your computer or iPad, the interpreter is able to interpret for the patient. By federal regulation, video remote interpreting, or VRI, satisfies your obligation to provide a qualified interpreter, provided that some conditions are met. You need to have high-speed internet access with sufficient bandwidth. right? So you have high quality audio and high quality video. The screen has to be sufficiently large. You need to have trained personnel to set up. Now, if you meet those requirements, you can use video remote interpreting. Many patients or residents will object to your use of VRI because they prefer live interpreters. You have to really understand what their objection is. If their objection is they just don't like the use of VRI, they would prefer a live interpreter or an in-person interpreter, you could still require them to use video remote interpreting. But if there's a particular reason why video remote interpreting would be ineffective to them, then you have to go to another method. And there are some contraindications to video remote interpreting. People who have low vision, for example, it's difficult for them oftentimes to see the interpreter via an iPad or a computer screen. If somebody has a pretty significant mental illness, they may find it very difficult to use VRI because they may find it to be, paranoid by communicating through some type of a video or computer system. And people with significant mobility disabilities may find it difficult to make sufficiently large enough hand movements so that their signing could be picked up by the interpreter remotely. As long as those contraindications are not there, video remote interpreting is a perfectly fine alternative. So let's now go into the next topic, which is service animals. So the ADA, as well as the New York City and state statutes, has a particularly stringent, careful definition of a service animal. It's a dog that is individually trained to perform tasks or do work for the benefit of a person with a disability. Dog. Emphasis is on dog. No other animals qualify except some miniature horses. And the task or work the animal does must be directly related to the person's disability. Prime example of that is the classic seeing eye dog. That is a dog that is individually trained to perform tasks for a blind person. The task that dog performs is directly related to the person's disability and blindness. A seeing eye dog is a service animal, okay? Very important. There's a distinction between service animals and emotional support animals, and we'll come to those distinctions later. With regard to service animals, your obligation as a public accommodation is to allow service animals, we'll call them service dogs, or miniature horses in certain circumstances, in all areas in which the public is customarily invited or permitted, okay? So, pretty much throughout the run of a nursing facility, you have to allow service animals, okay? An example would be if there's a sterile room because a patient has some type of an infection and or an isolation room or something, and you do not allow visitors in that isolation room, you may be able to prohibit the service animal from accessing that room. But other than that, if it's a place where you would allow a member of the public who is visiting the resident to go, you must allow the service dog, okay? The one exception, if the facility is not required to allow a service animal to remain if it poses a direct threat to the health or safety of others. So if it's lunging or growling at a resident and the resident who's the owner of the service animal is unable to stop the behavior, the dog might have to leave. It's also the obligation of the resident to care for the dog, to make arrangements for feeding the dog, walking the dog, things like that. But in all of these requirements, although it's not entirely clear, we would say that the reasonable accommodations rule applies. So if you have a strict policy that you're not going to walk a resident service animal, but that person, because of their disability, is unable to walk that service animal themselves, you may have to make a reasonable accommodation to your policy to allow a staff member to do the walking in certain circumstances. If this is an issue that comes up, we strongly recommend you consult legal counsel to really kind of go through it because it's a complex area. Okay. Now, what can the facility ask about a service dog when a resident comes in and has a service dog? Well, two basic questions are all you can ask under federal or state law. Is the animal a service animal required because of a disability? Yes or no? And then what work or task has the service animal been trained to perform? Those are the only two questions you can ask about service dogs. What you can't ask is details about the person's disability. You can't require medical documentation saying that the resident needs a service animal. You can't require that the dog or other animal have a special ID card or training documentation. And you can't require that the animal demonstrate its ability to perform the work or task. Any of those things would constitute disability discrimination. Now, we just talked about service animals, so now we're going to go into emotional support animals, which is another whole area in and of itself. Okay? Because nursing facilities provide housing on a more than short-term basis for residents, nursing facilities are subject to the provisions of the Fair Housing Act. And the Fair Housing Act requires that emotional support animals be permitted in residential facilities. So emotional support animals, nursing facilities, unlike other healthcare providers, nursing facilities have to allow them in the premises, okay? Now, who are entitled to have emotional support animals with them? Only residents with emotional or mental disabilities. A resident who does not have a documented emotional or mental disability, you can exclude that resident's emotional support animal. Only residents with emotional or mental disabilities are allowed to have emotional support animals. And the definition of emotional support animals is broad. It's any animal that can provide the resident with emotional support. It is not limited to dogs, miniature horses, any animal. But again, emotional support animals are only permitted if the resident has emotional or mental disabilities, okay? And the facility can require the emotional support animal to have a certification letter from the resident's mental health professional that the resident has an emotional or mental disability and thereby requires an emotional support animal. Now, it's important that this certification letter must be from a mental health professional, psychologist, psychiatrist, social worker, other type of therapist. It cannot be from the patient's or the resident's internist or primary care physician. It must be from a mental health professional, and it must certify that the resident has emotional or medical or mental disability. Now, assuming that the emotional support animal meets these requirements, the facility cannot charge a fee for housing the emotional support animal. But if the emotional support animal causes damage to the premises, you can hold the resident monetarily responsible for the damage. And of course, if the emotional support animal poses a direct threat to the health or safety of other residents or staff, you may be able to exclude the emotional support animal. If this occurs, it's really a time when you need to get legal counsel engaged to understand and to go through the issues, because it's a relatively thorny concept. And the facility can always prohibit overly large emotional support animals. Like a patient can't bring in a full-size horse, for example, as an emotional support animal, okay? So that's the distinction between service animals and emotional support animals. So let's talk real quick about removal of architectural barriers. This is usually not a problem for nursing facilities because they must follow the hospital code when they're constructed, and because they are, by definition, nursing facilities for people who are undergoing certain types of rehabilitation as a result of mobility or other disabilities, they generally have architectural barriers removed. It's not an issue. But if there is an architectural barrier that's not removed, the facility has an obligation to remove an architectural barrier that prevents a patient or a resident with disabilities from fully accessing the facility services. And this, of course, is more than true architectural barriers. It could be just accommodations like, access to bathrooms, counters being lowered so that a person with the wheelchair can see over the counter, things like that. Okay? And what your obligation as a facility is with regard to barriers is dependent upon when the facility was constructed or substantially altered. There are different guidelines based upon the year that the facility was constructed or last substantially altered. Okay, but regardless of that, you always have to undertake readily achievable barrier removal, even if the facility was constructed before 1990 when the ADA took effect. And reasonably achievable barrier removal would be to make sure that there's always an accessible path of travel throughout the facility, so for residents can get into their room, can get into the dining area, can get into the shower room, can get into where therapy is, and all the places where you expect them to go. You have to have accessible signage. So the signage for patients should be brailled so that residents who are blind can access the signage. The signage should be at wheelchair eye level for people in wheelchairs, mobility disability. And you have to make sure you have accessible medical equipment, Hoyer lifts, and other things for persons with mobility disabilities. Okay, let's now go into website accessibility. So, the Department of Justice has interpreted Title III of the Americans with Disabilities Act as obligating websites to be accessible to persons who are disabled. Okay? So if your facility has a website and you use that website as public-facing, it's used to advertise the facility's services to members of the general public, then that website must be accessible to persons who are disabled. And although the statute does not set forth, nor do any of the federal regulations actually set forth by what standard you judge website accessibility, the Department of Health and Human Services strongly suggests application of the Web Content Accessibility Guidelines 2.0 AA standard. This is the standard that the Department of Justice uses in its settlement agreements. And so let's go through some of the ways that you have to ensure that your website is accessible to the disabled. First of all functionality on your website has to be available from a keyboard, because people with certain mobility disabilities will not be able to use a mouse. You have to make sure that any functionality on the website is available from a keyboard. Second, you have to provide users enough time to read and use content, right? Persons have some cognitive disabilities, maybe low vision, or some mobility disabilities. It may be difficult for them to navigate the website. You have to avoid situations in which things are timed out after a certain number of seconds so that they have a hard time to use it. You have to not design content in a way that is known to cause seizures. Flashing lights, erratic movements, things like that can often cause seizures. And persons with epilepsy disorders, you have to make sure you avoid those things. You have to provide ways to help users navigate, find content, and determine where they are. Simply, for people with mobility disabilities or people with cognitive disabilities, they have to understand how to navigate the website, go back, find content. You have to make text content readable and understandable. So high contrast, large enough print, ways to blow it up, things like that. You have to make web pages appear and operate in predictable ways. And you have to help users avoid and correct mistakes. Perhaps the biggest issue regarding compliance is the concept of alt text. People who are blind or have significantly low vision rely upon programs known as web crawlers to go through the program, and or speech readers, they're also known as, in order to go through the website and convert the text and images on the website to speech. Your website must, behind all images, have what's known as alt text, so that a description of the image or the icon in text is supplied. That enables the screen reader to orally tell the person with low vision what the image or icon is. If you do not have alt text, it's almost impossible for the screen reader to accurately say what's on the website. So that's something that you need to make sure occurs. So how do you make your website ADA compliant? First of all, you have to identify publicly accessible parts of your website or parts where disabled employees may be accessing your website. You have to do an internal assessment of what is and is not in compliance with the standard, make appropriate changes, and do continued audits and other compliance checks. Because as you add stuff to your website, it could potentially go out of compliance. And you have to be continually asking for feedback from persons who are disabled about the usability of your website. So let's now talk about opioid use disorder. So the Department of Justice this year classified opioid use disorder as a disability covered by the ADA. So this means that facilities cannot discriminate against somebody who has an opioid use disorder. So you can't have an eligibility criteria, for example, for your facility that prohibits you from providing services to persons with opioid use disorders. You also, even if you don't have something that actually prohibits persons with opioid use disorders as residents in your facility, you can't have neutral eligibility criteria that tend to screen out residents with opioid use disorder. For example, many providers, many facilities have historically had policies against administering Suboxone or other medically assisted treatment for opioid use in their facilities. They say, we don't want to have the liability, we don't want to have the security issues, we don't want to have the hassles associated with providing residents with medical assisted treatment such as Suboxone, methadone, things like that. So they've had those policies. The Department of Justice has said it is disability discrimination to have those policies, because essentially you're creating a barrier or an eligibility criteria that screens out residents with opioid use disorders. So you have to make sure that you do not have a requirement in your facility, such as prohibiting medically assisted treatment or other things that would tend to screen out residents with opioid use disorders. Essentially, you're supposed to ignore the existence of opioid use disorder when making decisions about admission to your facility. Okay, so you should review your policies and procedures, your admission and eligibility criteria, potentially consult with an attorney to determine and make sure that your criteria are neutral with regard to opioid use disorder. Okay, now we've talked about all these different things. Let's talk about what happens if you don't comply. Well, if you don't comply, either an individual resident or a government agency can bring an action against you for failing to comply with the disability discrimination laws. And they could obtain an injunction, a court order requiring you to come in compliance. They can get money damages against the facilities. They can recover their attorney's fees from the facilities. You're going to get negative publicity. You're going to be on the government's radar. Okay. The agencies that enforce the ADA include the United States Attorney's Office and the Office of Civil Rights. Okay. And you're going to have to incur significant costs to remediate the situation, provide training to your staff and things like that. So non-compliance presents significant monetary and publicity risks. So you should do everything in your power to avoid issues of non-compliance. And it's very important, all facilities need to have comprehensive disability rights policies. Every facility needs to have a disability access coordinator, grievance procedures. You have to make sure that your staff is trained as to disability access procedures and policies. So let's now go to some questions as we're at the end. The first question is, do emotional support animals, do the requirements of emotional support animals apply to a daycare program located in a skilled nursing facility? My belief would be no, that if it's a daycare program and the program attendant involved, right, attendee, I should say, is not a resident of the facility, but is somebody in the community who's just coming there to receive the services of the adult daycare program, then the emotional support animal requirement would not apply, because that daycare program is not subject to provisions of the Fair Housing Act. The next one is, can we get a copy of the slides? And I believe that they are going to be made available after the presentation. But if you have any questions, you'll see my email on the final page, or I'll give you my email, and you can ask me any questions you want after the fact. Last question is, what happens if you don't have a doctor who is authorized to order Suboxone or other medically assisted treatment which requires this? That's an interesting question, and I think that it requires that you have to have some type of policy or procedure in place that if you have a resident who needs that type of treatment, you have the ability to get a doctor in to order that. And I think that would be the requirement. I think that's what would be, that's what the Department of Justice would say. But if who's ever asking that question wants to talk about it further, I'd be happy to talk about it with them offline, because this is a new area and everyone's kind of struggling with these policies now. What I'll say now for the current time is, if you have any questions, if you want to talk to me about anything, I'd be happy to talk to you, and I'll give you I will give you my email address right now. You'll also have it when you have the slides, but I'll give it to you now. And it's, my name is Roy Breitenbach, and it's R Breitenbach, R-B-R-E-I-T as in Thomas, E-N, N as in Nancy, B as in boy, A-C-H, at Garfunkel, G-A-R-F-U-N-K-E-L, Wild, WILD.com. Okay, thank you very much. Enjoyed speaking with you today. And as always, if you have any questions, please feel free to call me. I'd be happy to talk to all of you.